Welcome back, viewers and listeners, as we're going to try to start putting this onto a podcast outlet, not just, YouTube, to our latest episode of Across the Pond podcast with Martin, Cullip, and I, both at the Taxpayers Protection Alliance. And today we're kind of keeping it in America. Sorry, Martin, that he doesn't know what to talk about on this, but we've got Greg Troutman that's going to be our guest today. He's a lawyer who's been working on behalf of vaping manufacturers and associations and the consumers pretty much for several years. He's also a lawyer with the Kentucky Smoke Free Association. And I've known him for a while now. I was thinking about it today. That one of the very first times that I met you is when we testified in front of lawmakers in Heartland, Wisconsin, in 2017.
Yep.
Yeah, so 7 years ago. So
it's hard to believe it's been that long.
I know, and still dealing with the same issues. So, and well, thanks for joining us today, especially giving us some insight on all the stuff on vaping related to the legal system. Can you explain to our listeners and viewers, who you are, how you kind of got involved with this, just a little bit of background?
I'm a solo practice attorney in Louisville, Kentucky, and I've been involved in this. Actually, I'm coming up on my 11th anniversary this month. How I got involved was purely by accident. I had left a firm in downtown Louisville. I was looking for a new office space in close proximity to my reserved parking space. Walked into a Regis office, and Regis is an international company that takes office blocks and leases them, carves them up, leases them out. Happened to meet a young guy named Troy LeBlanc, who was the property manager for Regis. Troy was selling the vapes at a mail order place on eBay site. I didn't have anything knowledge about vapes. I see him using them every day, following him around. The sweet smell, follows him. He comes in one day. We hit it off really well. He comes in one day and sits down and says, "Hey, I'm thinking about leaving this and opening a storefront." We talked and we talked and we talked a bit. And I've represented him ever since. And that got me started in the vape industry in May of 2013.
Wow, 11 years. And I always feel that I got involved in like 2016. So, Martin, you've been involved with vaping just around the same amount of time.
And for full disclosure, I've never smoked and I don't vape.
Well, that's good. We wouldn't want you to vape if you never smoked.
Right.
So
I do descend. I also, full disclosure, I do descend from 8 generations of tobacco farmers in the far western part of Kentucky. So this is probably my penance.
I like it. I like it. Well, okay. So one of the things I did want to talk to you about, because you're coming at it with the law degree and the law side, and a lot of people don't really understand in America, the courts have had a very big influence on the introduction and the regulation of e-cigarette products. Can you kind of explain the history of that, like going back to, because you brought up eBay, going back to the Cetera case, and how FDA did come about getting the regulation on this?
Well, it goes back even further than that, back into the mid 90s, is that Congress over the years, ever since the Surgeon General's report, has entertained different ideas about regulating tobacco in various forms. And over the years, they have introduced a lot of regulations as far as advertising and restrictions, branding restrictions, marketing restrictions, and so forth. You remember you used to be able to smoke on an airplane. Remember there used to be smoking sections on airplanes. Well, federal legislation is what banned that, and they did it first on short flights, and they did it on long flights, and they did it now on all flights. So that was, piecemeal was how they went about it. But Congress had never given broad authority to regulate tobacco to FDA. FDA got tired of waiting, and in, I think it was 1995 or 1996, they introduced a rule that would regulate cigarettes as a drug, because they declared nicotine was a drug and cigarettes were a drug delivery device, and so they tried to regulate tobacco that way. Well, a number of the legacy companies sued, Brown and Williamson being one of them. And it gets to the Supreme Court, and the Supreme Court ruled, I think it was a unanimous decision, that and this Brown and Williamson case has broader implications down the road, as hopefully I'll get to talk about. What the Supreme Court said is that the regulation of tobacco products is a major question because it involves such a huge aspect of the federal and the U.S. economy, plus the broad history of tobacco going back pre-revolutionary times. So they said that is a major question that only Congress can give authority to the agency to regulate. And because Congress had not given FDA authority specifically over tobacco products, FDA lacked that authority. So moving forward over the years, nothing happens. Later 2000, later 90s, early 2000s, until we get to 2009. Congress adopts the Tobacco Control Act, finally gives FDA authorization over the regulation of tobacco products. And what Congress did, and I think this is an argument to get rid of part of the TCA, is that Congress followed what Brown and Williamson said, and it gave the regulatory framework for 4 specific product subsets, cigarettes being one of them. And it left to FDA to decide what it was going to regulate by a rule. They could deem other products that met the tobacco product definition as being subject to the Tobacco Control Act through a regulatory process. I think that violates Brown and Williamson. Brown and Williamson said if regulating tobacco is a major question, to me it seems that part and parcel of that is defining what you're going to regulate. I think it was incumbent upon Congress to define what it was going to regulate and specify the product subsets that were going to be regulated, not let FDA decide that. I think that is a non-delegation issue and a major question doctrine issue that is ripe for the courts to answer. But be it as it may, moving forward, nothing happens with vaping products until May of 2016. FDA issued what's called the deeming rule. And the deeming rule brought within FDA's control all other products other than the 4 original product subsets that meet the tobacco product definition are now subject to regulation by FDA. That is when FDA got control over vapes. That deeming rule was effective in August of 2016. It had a requirement for a pre-market tobacco application to be filed in August of 2018. And what a pre-market tobacco application is, if you were not on the market, if you did not have a tobacco product on the market as of February, I think it's 15th, 2007, you're considered a new tobacco product. Even if you were on the market before the deeming rule took effect, you're still considered a new tobacco product. That's a logical disconnect, but that's another story. You have to file a pre-market tobacco application to remain on the market. And the deadline for that was August of 2018. Well, FDA in the deeming rule said, we don't think we're going to get more than 2,500 applications. And so they set deadlines that would have made pretty good sense for 2,500 applications. Well, they received 6.7 million, as we know. So those deadlines were absolutely ridiculous for that many applications. This is a process that should have taken probably 10 years to roll out. And the reason why I say that is it's like an accordion. There are aspects of this regulatory process that have to have internal rulemaking. What were going to be the requirements of a PMTA? That's not set out in the deeming rule per se. There was going to have to be more regulatory work done down the stream to get you to so you know what's going to be in the PMTA. FDA did not promulgate its PMTA rule until after the PMTA deadline. And then it wasn't effective for several months after that. It's like, closing the door after the horse has gotten out, the barn door after the horse has gotten out. This is a process that should have taken probably at least a decade to roll out. FDA crammed it into a short period of time. There's a lot of political pressure here. The deeming rule was done months before the election in 2016. It was one of the Obama's administration was trying to get this out of the way before they left. So there's politics involved here all around the works. So we get to into the deeming rule process. We have a change of administration in January of 2017. Trump people come in and they realize these deadlines aren't right. So they set new deadlines and they move the deadlines out 4 to 5 years. The problem is the Trump administration did not go through the rulemaking process. That is, notice they have to publish a public notice, take public comment, distill those comments, and then create a rule based upon the comments. They didn't do that. They just said, we're changing the dates. Well, the American Academy of Pediatrics and some of the other anti-tobacco groups sued, and they cherry-picked, found a favorable court in Maryland, sued, and the court agreed with them that FDA had violated the Administrative Procedure Act, had not engaged in notice and comment rulemaking, and set aside the new 2022 dates. And in doing so, the court arbitrarily set a May 2020 date, so moved the dates back approximately 2.5 years. Well, this was in the middle of COVID. Nobody saw this coming. The labs that you would need to have your testing done. Well, these people were working from home. They weren't in the labs working. So it made getting the testing done that we thought we were going to need to do quite impossible. So people filed their PMTAs timely. And we did get the judge to move the date 6 months ahead to September of 2020. So people did file their PMTAs. Again, 6.7 million product PMTAs were filed. FDA had a year, the judge in Maryland set a year deadline for them to review the PMTAs. So we move forward to late summer 2021. FDA's interim director at the time, Janet Woodcock, goes before House Oversight, gets grilled in what I refer to as a dog and pony show hearing, but gets grilled because none of the PMTAs have been denied yet. Within 2 weeks of her getting grilled, a secret memo is crafted. And we find this out in a FOIA request, but a secret memo is drafted within FDA that says, we're going to review flavored product PMTAs using a heightened standard that nobody knew and nobody expected. Comparative efficacy. You have to compare the benefits of your flavored products to your tobacco flavored products in bringing about smoking cessation. Well, nobody had done this comparative testing because FDA had told us in the lead up, oh, we're not going to require this long-term testing. Don't worry about that. That's something they were going to do on the back end. Well, they create this secret protocol after the PMTA deadline, not allowing anybody to update their PMTA, so there's no notice to anybody. The first thing we know is starting in late August, early September of 21, as we approach the year deadline, mass market denial orders start coming out. They were cookie cutter. They all said exactly the same thing. The technical project leads, TPL documents that accompanied the market denial orders, all pretty much read verbatim from the secret memo that FDA had promulgated. Even down to the footnotes, it was almost verbatim. The industry starts fighting back. You started seeing a number of industry players file appeals in the federal appellate courts. And how this works is you had to file in either the District of Columbia circuit or the circuit where your business was located. And so there are 12 federal circuits, regional circuits. We had cases pending in 10 of those 12 circuits. The 2nd, 3rd, 4th, 5th, 6th, 7th, 9th, 11th, and DC circuits. And then actually now 10th circuit, 10th and DC circuits. So we were all over the country. I did amicus briefs in a number of those cases. I had a merits case in the 7th Circuit, which unfortunately I lost. We started seeing mixed results. The 11th Circuit came out and ruled in the industry's favor. The 5th Circuit initially ruled against the industry. Well, the Fifth Circuit initially granted a stay and issued an opinion that referred to what FDA did as a surprise switcheroo. That was the famous, I think it was in October of 21. That was the famous surprise switcheroo opinion. Then the different panel of the Fifth Circuit ruled for FDA. And you started seeing reflexively the other circuits fell in line. And we got rehearing, en banc rehearing in the Fifth Circuit because it was a split 2-to-1 decision. It was a very strong dissent. Well, the Fifth Circuit is probably the most conservative circuit in the country. And we got a majority of the judges to agree to rehear the case. And we had a rehearing in May of last year in New Orleans in front of 16 members of the Fifth Circuit. And walking out of that, and I did amicus briefs in that en banc case. Walking out of there, I knew we probably had won just from the reaction of the judges. And the judge who ended up writing the opinion, Judge Oldham, for a lot of people who don't realize this, during the FDA's lawyer's argument, he was snickering through a lot of her argument. And at that point, I knew, okay, yeah, we got him. And I pretty much figured he would write the opinion. And sure enough, he did. So we got that. So what we've got is we have a circuit split. We've got the 5th and the 11th circuits have said, we agree with the industry on one aspect of this or another. We've got these other cases from the different circuits that say we agree with FDA. Well, when you have a circuit split, you end up in the U.S. Supreme Court, which is exact where we are right now. We have got 4 cases pending. Magellan out of the 2nd Circuit, Logic out of the 3rd Circuit, and Lotus out of the 9th Circuit were the industry cases. FDA appealed its loss in the 5th Circuit in Troutman and Vaptasia. So we've got now 4 cases pending before the U.S. Supreme Court on what's called a writ of certiorari, petition for writ of certiorari. And that's basically they're asking the court to take the case, to hear the case. And if the court takes the case, and we will know this probably within the next month to 6 weeks, because now all of 4 cases have their petitions and responses filed. Some of them have the replies filed. The court's going to take these up in a conference within the next few weeks, and will decide whether to take the cases. And we believe the court will take at least one of the cases, maybe perhaps all 4 of them consolidated, and we will get a decision in this case, hopefully early in 2025. If the court takes the cases, I believe at least, based on the calendar I've seen, they could be argued sometime either in October or November of this year, which means we would get a decision probably February to April next year. So a year from now, we could be sitting here knowing where things stand. The light is at the end of the tunnel.
Well, that was very succinct and over-encompassing and a really good review of everything that's gone on with the courts. Martin, do you have anything?
Yeah, it's a great rundown. I've heard little bits of it before on things you've done with Regulator Watch, I think, but I've never had the full history, which is fascinating. But can I ask, what say you did win these cases in the Supreme Court, does that just send it all back to square one, or what happens then?
Well, if we win in the Supreme Court, what it will do is, yes, it would be sent back to FDA, but the instruction from the court would likely be, FDA, if you want to, and this is the crux of the case, FDA is impose a de facto ban on flavored products, in essence. Well, the Tobacco Control Act has a mechanism, a procedural mechanism for FDA to regulate the ingredients or constituents of a tobacco product standards. Tobacco product standards require notice and comment rulemaking, which I talked about earlier. FDA would have to publish a proposed rule, would have to take public comment, would have to distill those comments, would have to then come out with a formal published rule which addresses the comments. That's not a process that happens overnight. That's a process that's going to take a year, 18 months, maybe as long as 2 years to accomplish. In the meantime, it's not going to be able to regulate flavored products according to that rule before it goes through that process. So we're going to be in a 2-year, 18-month to 2-year period of limbo. So, you know, the lawyers for the industry are already beginning to talk about, okay, what happens if we win and what's our next step? How do we address this? How do we push this forward to force FDA's hand to do something? Quite frankly, what I think is going to happen is if the Supreme Court grants these petitions, I think you're going to see Congress step in and do something to reform the PMTA process and amend the TCA. The Congress is going to step in and do this before the courts force them to do it. They're not going to let there be a regulatory vacuum, which, by the way, we don't want either.
Well, it's almost that we live in a regulatory vacuum when you look at it. I mean, to date, as of May 22nd, 2024, FDA has only authorized 23 e-cigarette products, even though we can see from all the data that you're seeing an increase in adults using these flavored products that are completely, you know, FDA. And I guess, what are your thoughts then on what the FDA is now doing with the DOJ and going after these products that didn't, you know, file? Because I've always sat here and said it's kind of like, the small vapes really, they're really in this unique position. It's really unfair to the big people who actually got PMTAs through to be losing a lot of money, but at the same time, the whole process is unfair that only 23 products have been authorized, and that, you know, and all the stuff stops at FDA. What are your thoughts on FDA using, and, you know, using now the courts to go after these products?
Oh, well, they're not just using the courts to go after them, they're using the administrative process, because they're either bringing cases in federal court or they're bringing administrative cases through HHS. They're seeking civil monetary penalties against people. So you've got both of those. You know, quite frankly, the folks that had got their PMTAs authorized, they had a thumb on the scale. I don't feel sorry for them one bit. You know, they're the same people that have gone around trying to get the legislatures in the states to pass registry bills, which I'm proud to say, yes, I hate it in my own home state, and we're litigating that right now, that they did pass a semi-registry bill. But I'm happy that we engaged this year and we beat back more of the bills than we lost. We won more than we lost.
Yeah, for our listeners and viewers on these PMTA registry, these directory bills, what they are is they're having the states now pretty much enforce the FDA regulations. So instead of the FDA coming down and, you know, going after vape shops selling, you know, an elf bar, so to speak, the states are now doing that themselves and using their own justice departments, which I think is, one, a waste of money, a waste of, like, you know, state expenses. And also, we've been kind of against them just because at this point, if you are in favor of them, you're almost, you know, declaring that the FDA PMTA process is, like, you know, worthwhile. And I've been complaining about it since 2016. Okay. I mean,
well, and I'm proud that in the Deep South, Mississippi, Alabama, Georgia, Florida, South Carolina, all either beat them back or totally turned the tables on the big tobacco companies. Florida was the turn of the tables.
Yeah.
On big tobacco. And that was the industry engaging at the ground level. In his meetings with, I was engaged by the Alabama group. I've been down there a couple of times, and it was meeting with legislators, meeting with senators. And I'll tell you what helped kill Alabama. And this was luck. First time I went down there in February, met a senator. Last meeting I had of the day. And he says, yeah, he found out I was from Kentucky. He goes, yeah, me and one of my colleagues were coming up in a couple of weeks to do the bourbon tour. Like, give me your contact information. Just so happens that Troy, my main client, owns part of a distillery in Kentucky. I says, I'll get you hooked up. So we had dinner. They came into Louisville. We had dinner. Our lobbyist was there. Our lobbyist, by the way, represents Heaven Hill Distillery. Got him a personal tour of Heaven Hill Distillery. They were up here making the private selection picks to be sold in Alabama for the limited supply of bourbon, the high top shelf stuff for Alabama for this year. Troy gets him hooked up with the people at Buffalo Trace. Shows him a great time. Okay. Talk about luck. Oh, it just so happens that one of those senators was the one who was carrying the bill in HB 65 in Alabama when it got killed. Luck?
That's always luck. And isn't that the irony? Martin, if you're not aware, Kentucky, if you're driving on the interstate, that's all they're doing is, bragging about their bourbon industry. And it's like a big main ticket for tourism in the
yeah.
bluegrass state.
Yeah.
It's a huge deal. Well, there is a bourbon called Pappy Van Winkle, very limited production. And when the Liquor Barn, which is a big box liquor store here, when they get an allocation of Pappy Van Winkle, this would be like a case, whatever many bottles is in a case. There'll be people camping outside overnight for a chance to get just one bottle.
I know that one. That's the one. Isn't that the one that's got the silver pewter like horse on it? There's one bourbon that I always get. And the only reason
I don't think that's it, but it's a limited production. It's very much in demand. And it'd be almost like if they announced that the Beatles were getting back together and you saw people camping it. This is the Beatles of bourbon.
Yeah. Yeah.
Can I ask a question? Something for people who aren't in the States who might not understand this. The deadline of 2007, February 2007. That obviously is before vaping products had really appeared on the market, and it always strikes me that date was chosen not in good faith. It was almost like a way of just trying to ease these products out the market so that they couldn't apply for substantial equivalence. Do you know why they chose that date? Because it doesn't make any sense to people outside the US.
Well, they chose that date because that was the date that the Tobacco Control Act was introduced in the Congress.
Yeah, but
not the date it passed, but the date it was introduced. It wasn't passed for almost 2 years later.
Yeah, because I remember there were arguments at the time about it should be a date further forward to reflect the fact that vaping products were on the market, and there were many that, I mean, it basically said every cigarette product is fine for substantial equivalence, but none of the vaping products are.
I think there's a valid grounds to challenge that legally. Is that you're putting a date that was before the law ever took effect? That seems like it's after the fact. It's just something about that just rubs you wrong. You know what I'm saying?
Yeah.
And we have had amendments, the Cole Bishop amendment, that there has been congressional legislation introduced. It just hasn't gone anywhere to actually change that's called the predicate date. The 2007 one just hasn't really gone anywhere. And yeah, a lot of the stuff when it comes to the regulation of these newer products, but a lot of that would be solved if, we move the date up, especially, and we would just allow, I'd be like, I mean, we are living in a world where it's easier for you to bring a combustible tobacco product to market than, a safer alternative, because of that stupid freaking date. But we are getting towards the end of it. Okay. And I always like to go out with a bang. So like something that's, positive. So Greg, do you have any positive, advice you can give our viewers or our listeners, or anything, any hope?
I will tell you all what I tell everybody at trade shows when I walk the floor is keep doing what you're doing. It saddens me to see the number of store closings on social media. Keep doing what you're doing. We are so close to getting this fixed. The people who hold on and can get through this next few months are going to be in, I think, a really good position. Because one of the things that we're going to do, we will have a table at the seat before Congress if there is a reform. I can tell you we will have a seat at the table. We will help craft what that reform looks like. And one of the parts of the reform that I really will push is federal preemption. So it stops the state and local flavor bans. It would allow us to flourish again in California, New York, Massachusetts, the places that have banned flavors. A lot of that stuff would be barred if I have my way. So hang on, keep doing what you're doing, keep trucking. Let's get through the next few months, and hopefully we come out of the back of this in a lot better shape, and we go back to where we were in 2015, 2016.
The good old days. Okay, well, that's a really positive way to end it. Martin, do you want to do the closing, or do you want me to do it?
If you wanted to do closing, I just want to say, Greg, best of luck from all of us, and let's hope. You said a month to 6 weeks or something, we might hear some news.
I think the court closes its session for the term at the end of June. I think we will know before the end of June.
That'd be great. Well, fingers crossed for that.
Yeah, we'll definitely have you on another podcast on that one too. And thanks for joining us today.
Hey, thanks for having me anytime.
Awesome. Well, viewers and listeners, thanks for joining us for another episode of our Across the Pond podcast, or the Pondcast with Martin and I. Make sure that you check out our other episodes. And as always, if you have any guests that you would like to see, feel free to reach out to Martin and I, and we'll try to get them on the show. Thanks again.